We will go on the record in the matter 25 CF 150, State of Wisconsin versus Bradley Balile. The state appears through Assistant District Attorney Jose Vila in person. We have Renee Landgraf in person with her client, Bradley Balile, otherwise known as Oyat. We're set here today in this matter for a plea and sentencing. Ms. Landgraf, is this proceeding as such?
Yes.
All right. I have in front of me a plea questionnaire waiver of rights form that has been filed in the case. Mr. Oyat, did your attorney go over that document with you?
Yes.
And it looks like she has an electronic copy of that on her computer right there in front of you. Is that correct?
Yes.
Did she essentially go over that document with you word for word?
Yes.
And you understood everything completely?
Yes.
Is that your signature on the second page?
Yes, it is.
Ms. Landgraf, can you please recite the agreement for the record?
Yes, my client will plead guilty to count 1. The remaining counts will be dismissed and read in. There's a joint recommendation for a withheld sentence, 1-year probation, and then the mandatory costs and fine.
All right.
The condition is that to comply with the CHIPS case.
Comply with CHIPS. Okay, and Mr. Vila, this is in the public interest?
Yes, Your Honor, it is.
And this is as a party to a crime, correct?
It is charged that way. I did not put that part on the plea questionnaire, but
All right. So,
he admits that he directly committed it. So,
all right. So either way, he's taking responsibility and accepting that, correct, Mr. Oyat?
Yes.
So that is the agreement that you've reached?
Yes.
You are 48 years old. You have an HSED. You can read, write. You understand the English language. No mental illnesses or disorders. No alcohol, medications, or drugs in the past 24 hours, correct?
Correct.
Did your attorney thoroughly go over with you what the state would have to prove your guilt beyond a reasonable doubt?
Yes.
Did your attorney go over with you the maximum possible penalties you face?
Yes.
Because you're charged with crimes, you are entitled to constitutional rights. Each of those rights is listed on that first page. Did your attorney thoroughly go over those rights with you?
Yes.
Do you understand them completely?
Yes.
Do you need the court to go over those rights with you in any more detail?
No.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
Do you understand you're pleading guilty to a felony? As such, you will no longer be able to use or possess a firearm for life.
Yes.
No longer able to vote in any election until your civil rights are restored.
Yes.
Do you understand that on or around October 15, 2025, the state would have to prove you possessed a substance. The substance was a controlled substance and it was a methamphetamine, and that you knew or believed that substance was a controlled substance, methamphetamine. Do you understand what the state would have to prove?
Yes.
Do you understand the maximum possible penalty could be a fine of up to $10,000 or 3.5 years of incarceration or both?
Yes.
Do you also understand that it's charged as a party to a crime, but you are accepting responsibility for possessing methamphetamine?
Yes.
All right. And you understand what that means?
Yes.
Do you understand that even though there's a recommendation to the court for a withheld sentence and being on probation, I'm not bound to follow that. That means I could sentence you to the maximum possible penalty or any alternative sentence if I find that to be appropriate. Do you understand that?
Yes.
Do you still wish to proceed and enter a guilty plea?
Yes.
Did you go over the criminal complaint with your attorney?
Yes.
In particular, the section called the probable cause section, where it basically says what happened and why you were charged with the crimes?
Yes.
For the most part, are those facts accurate?
Yes.
Admitting here today, you in fact did possess methamphetamine
Yes.
and you knew it was methamphetamine?
Yes.
Ms. Landgraf, may the court use the probable cause section of the criminal complaint to find a factual basis along with the
Yes.
statements made?
yes, Your Honor.
Has anyone made any threats or promises to you, Mr. Balile Oyat, for you to plead guilty to this crime?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
Yes.
and voluntarily?
Yes.
Has your attorney represented you competently?
Yes.
Has she answered all of your questions?
Yes.
Has she looked at this matter thoroughly?
Yes.
Are you satisfied with her services?
Yes.
Any questions for the court or for your attorney before I proceed?
No.
And as to count 1, possession of methamphetamine, how do you wish to plead?
Guilty.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'll find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count 1. Counts 2, 3, and 4 will be dismissed. and read in for purposes of sentencing. Judgment of conviction will be entered today. Argument, Mr. Vila.
Thank you, Your Honor. Just to briefly remind the court, this is a case where law enforcement executed a search warrant at the residence and they found a plate of meth in the back room. Lab tested it. It confirmed it was meth. I believe the joint recommendation in this case is appropriate. While the crux of this case does stem from a personal substance problem, there's no denying that there were children in the home and that they were exposed to dangerous substances. But I do think the court should prioritize treatment with this sentence. As the court is aware in the ongoing Chips case, Mr. Balile has made contact with Perry Staples from the Drive concerning some AODA and other treatment options. I think he recognizes that he needs to continue to work on his sobriety, not only for his benefit, but for the benefit of his family. I think this sentence is structured in such a way that it incentivizes him to continue to make progress on his sobriety while also working towards having his children safely returned to the home in that Chips matter. Now, should he fail to take advantage of said programming while on probation, he would face revocation potentially. So that metaphor of the carrot or the stick, so to speak. As such, I would ask the court to adopt the joint recommendation. Thank you.
Thank you. Ms. Landgraf.
I couldn't have said it better myself. I would just add that he has 12 days credit if he's revoked, so it was an immediate consequence. He also has $500 bond posted. Hopefully that will cover most, if not all, of the fine and cost in this case.
Mr. Balile, anything you want to let me know? You want to talk to me about?
No.
Okay. This is off topic, but Ms. Landgraf is super smart and she can figure a lot of things out. I don't know if you have the ability to retain or do whatever, but to talk to her about your last name and that issue.
Oh, no, I haven't got to her in that, but.
It's a complicated, it's not really too complicated, but it's a complicated issue. He's known as Balile. His last name is Oyat. He'll explain that to you, but maybe you want to retain her or you want to do something or just ask her a brief question. I don't know. It's nothing that I can give him advice to, but that's why I constantly say Balile Oyat.
Yes, I represented before and it was the same issue. And I think in DLC it lists both names, but your driver license is Oyat. So I don't know why is it in the system as
The DOC had me, when I got sentenced to prison, they had me under Balile because I went by Balile all the way till I turned 18.
And then you officially changed your name.
I think my mom did, so.
Yeah, and that was the same issue with his brother Jonathan, but brother Jonathan stuck as Oyat.
Yes.
He is Oyat. And I just know that it causes a little bit of complication in some of the cases. Hopefully we're not going to have more cases. They're all going to get resolved. However, it also causes angst, Mr. Balile, Oyat. So that's just why I brought it up.
Well, can the DA system, can you change it in your system?
Mr. Schmidt said no. He
Yeah.
said that's how it comes through for whatever their system is, and they have no ability to change it unless they get, I forget.
There's a long list of like technical things that need to be checked all the way at the top of who manages Protect all the way down for them to fix it. And they told us it's not possible unless we get it referred out the gate and then we can update that on the back end.
So let's just not get any new cases, but still, I just know it, I know it upsets, it bothers you. I don't know if it upsets you, but it bothers you. So you don't want to tell me anything. I have a very good knowledge of your history, Mr. Oyat, as well as, you know, your family history with Lil Bradley and Dominique, and your past criminal history and your substance abuse disorder. And so I understand that you were doing so well. I don't know what caused the slip and the relapse or when that actually occurred, but you and I both know that you and Dominique need to be strong and you need to be sober and present and there for Bradley because he needs you. It's your only kid.
Yeah.
You know, and he's looking up to you and he has your name. As your name should be. And he's watching all that you do in life. And I know just by knowing you and knowing where you've been and where you want to go, you don't want him to be seated in that chair anytime at all in his life. And so hopefully you're going to be able to find the treatment options and have things that you can do so you can better yourself and you can better your life and you can better Bradley's as well. because he's a cute little kid. And I don't know if I've ever seen you happier than, I know you didn't really want children or weren't looking to have children until you have Bradley.
Yeah.
And then I know that he has warmed your heart and your soul. And that's a good side to see of you, Mr. Oyat. So I want to see you use those treatment options and be on probation because you're completely off of ES, right?
Yes.
And so you're going to be on paper yet again. And but hopefully it's going to go smoothly and it's going to go without a hitch and you're going to do what you need to do. So with regards to this, I forget what you said, the length of 1 year of probation. I'll follow the recommendation for 1 year of probation. I'm not going to do with a withheld sentence. I know you've been to prison. I know your criminal history and some things have been a little bit more serious than others, but this will never be a prison case. And I don't want anyone to think that this is ever going to be a prison case. This is as it's charged with how the facts are fleshed out. This is a need to protect you, need to protect Bradley case.
Mhm.
And if anything, and you're not able to do that, it really is a treatment case and it should never be treated as prison. So if you are revoked, I'm going to order 9 months imposed but stayed jail time. Conditions of probation comply with DOC and any treatment recommendations that they have or any other programming that they have or they want you to partake in. Absolute sobriety, no use or possession of any illegal drugs, substances, or paraphernalia, regular substance testing, comply with the CHIPS case and that underlying matter until that is complete and you're able to move on from that. I think that's all with recommendations. Have you looked at undying? Is that how?
Yeah, I think that they turned that into
Group home now?
or sober
Sober
living
living?
or something like that. I gotta talk this Perry and figure something else out. But
Please do.
yeah, I am.
Okay. All right. So again, felony, no use or possession of any illegal drugs, substances, or paraphernalia. I do need to order. You have $500 cash paid. I don't know if there are any surcharges, but Ms. Landgraf, you indicate that there are surcharges, or you think that there are, so it would be approximately $550.
I think it's $518. Yeah, unless the
Okay.
court will waive $18 of the court cost.
That's what I'm gonna do. But I was just wondering, am I missing a surcharge or something? Because some counties, for some reason, have other things that are added on.
I don't think Burnett County does. I know Polk County does like a standard $10 fine for like everything.
Washburn does something like that too. But what I'm gonna do is I'm only gonna order $500 in fines, fees, and court costs, waiving the 18. I think that you have most of it there, so we should be good to go. 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I do need to order your DNA. You're going to need to go to the jail and make sure that they have it. I know we have it on the system. However, I still have to order it. You still have to see, because I think they have to go per case and all of these things. You would have the ability to request your DNA for this case be expunged through a letter to the Department of Justice, not to me, but to the Department of Justice. I don't know, your DNA is in the system, so that's up to you for you to figure out with this case. I think that covers everything. Mr. Vila?
I would agree, Your Honor. I think you covered it.
12 days credit.
12 days of jail credit if you are revoked. All right, you can come get your document to go to the jail and you are good to go. Thank you.
Thank you.
We will go on the record in the matter 25 CF 160, State of Wisconsin versus Robert Teskey. The state appears through Assistant District Attorney Jose Vila in person. Mr. Teskey appears in person with counsel Joel Feliski. We're set today in this matter for a status conference. Mr. Feliski, please update the court.
Thank you, Your Honor. I've received the discovery in this case from the state. I've had an opportunity to review that alongside Mr. Teskey. Based on those observations, Your Honor, I'm currently in the process of drafting a suppression motion. I'm anticipating having that completed and sent into the court within the next 2 weeks.
Swear you're going to have it done and filed by 2 weeks.
Would you like me to swear on the record, Your Honor?
I appreciate you saying that. It's just, I'm gonna tell you, Mr. Schmidt, I know this is Mr. Vila's case, but Mr. Schmidt likes me, and I do too, like to make sure with attorneys that I'm not as confident of filing within the time limits they tell me they can do it, to have them file the motion first before we set the hearing.
Certainly.
That's why I'm pretty confident I can trust that you're going to get it done in 2 weeks. If you're telling me you're going to get it done in 2 weeks.
Your Honor, out of a latent conservatism, why don't we make it 3 weeks?
Okay. So you need 3 weeks, and then the state will need 2 weeks to be able to respond,
That should be enough, Your Honor.
or I can give you 3 weeks too.
3 weeks is fine as well.
Okay, so that means 6 weeks. Okay. How many witnesses do you think this hearing's going to require? Witnesses from officer or testimony from officers? I don't know what the issue is, honestly.
I'd budget 1 unless you feel like
I
you
would
need
think it
more.
would be 1.
Just the main officer, so.
You think we can get it done in a half an hour?
I think that should be sufficient.
I could give you April 13th at 2 o'clock. Oh, wait, did I just give you 6 weeks to be able to do these things? That is not going to be enough time for you to do your response and for me to fit it in. Okay, give me a little bit more time. I'll give you more time. April 30th, anytime from 9 until 11.
That will work for my calendar, Mr. Teske.
Does 9 o'clock work? So your motion's going to be due by March 5th. And yours is going to be due by March 26th. Well, I guess I could go earlier than that's giving a whole month. I don't think we need a whole month. Okay, so we could have it that week that I did plan, the April 13th at 2 o'clock,
Unfortunately, I'm in Washburn for another hearing, Your Honor.
April 16th at 9:30.
That will work.
All right, let's do April 16, 9:30. Just block that whole chunk that's open. What? You don't, is it, oh, you don't see it,
Yeah.
okay. I'm sorry, I don't know that you don't see what I see. 9:30 to 10:15. Just in case. All right, so you have your times, yes, Mr. Vila?
Just looking at this, my main witness is Officer Brady Mogen, who was in dog school at that time.
Well, here's the deal. I'm gonna tell you right off, I'm not
No.
waiting that long. I'm not
Okay.
waiting until August when he gets back.
Fair enough. Understood, Your Honor. Well, I'll figure it out.
So it is what
Understood.
it is. The court doesn't hold because people have training.
I understood. I just figured I'd bring it up now.
I totally appreciate that
Yeah.
because I get it and and I respect that, but we have to keep the wheels of justice moving.
Fair enough, Your Honor.
Okay, thank you. Then we are adjourned. We're off the record. When does he actually leave? March?
I believe he's leaving next week.
Oh, yeah, so, sorry.
Nope, that's fair. I understand. The court has to do what the court has to do. I think I might have missed it. Did you say March 26th was my deadline for the motion?
Yes.
All right, thank you. And then April 16th at 9:30 is the actual motion hearing day.
Correct.
Perfect.
All right, Mr. Hanson. We will go on the record in the matter 25 CF 168, 25 TR 941, 942, 943, 944. State of Wisconsin, Cody Burnett versus.
This hearing wasn't about dramatic courtroom confrontations. It was about accountability, second chances, and the consequences of every decision. From guilty pleas to treatment-focused sentencing, the judge made one message crystal clear. Rehabilitation is possible, but only if the defendant chooses it. Now it's your turn. Do you think the court struck the right balance between punishment and rehabilitation? Or should the sentence have been tougher?
Hansen. The state appears through Assistant District Attorney Jose Vila in person. Mr. Hansen appears in person with his counsel, Joel Poliski. We're set today in this matter for status conferences. However, the court's been updated or informed that an agreement has been reached. The court has approved changing the status conference over to a plea and sentencing. Mr. Poliski, please inform the court of the agreement that's been reached.
Thank you, Your Honor. Mr. Hansen has agreed to plead to both counts in 25 CF 168. On count one, the parties are making a joint recommendation for a deferred judgment of conviction agreement. On count two, the parties are making a joint recommendation for a fine inclusive of court costs. I apologize. I'll correct the record. It will be for court costs only on count two. I've gone over a completed plea questionnaire and waiver of rights form with Mr. Hansen, along with the deferred judgment of conviction I referenced with him as well. May I approach?
You may. Thank you. Thank you. We will go on the record, we are in the record, and Mr. Hansen, I have in front of me two documents. You recognize these documents?
I do.
Did your attorney thoroughly go over these documents with you?
That's correct.
Essentially word for word?
Yep.
And you understand everything on these documents?
Yes.
If you didn't understand something, did you ask your attorney to explain it to you until you did?
I did, yes.
So you understand everything?
Yes.
And did you sign these documents?
Yes.
You are 22 years old, 11 years of schooling. You do not have a high school diploma or equivalent. Why not?
There's a lot of moving around. So in 11th grade, I moved from Grantsburg to Kankakee. It's roughly 45 minutes south of Chicago. Moved in with my Aunt Jamie. Things didn't end up working out too well down there. So moved back up here. I gave that another try. And ever since then, it's been job to job. And the previous incidents, then went to a sober house. I got my priorities straight and just trying to fix what I messed up.
Okay. And do you have any intention on trying to get that GED or HSED?
I do indeed. I'm going to call up GHS after this session here, see if I can go and grab my transcripts and I can turn them into a community college down in River Falls. They do a free GED program and stuff like that. So
That's what I was going to say that I want you to do. And they have, it's the same community college, and they have a 2-week kind of boot camp.
Yep.
Where you can do it, and that's what you're looking at doing?
I was.
Excellent. You're making me happy because you're 22 years old, haven't talked to you much, haven't really seen you much on these cases, but you seem like a smart young man. You should have at least a GED or HSED.
Yes.
I think you can't get an HSED because you have to have a physical education aspect, but I'm not quite sure. I'm glad to hear that. Thank you for letting me know that.
Most definitely.
So you can read, write, you understand the English language, and did your attorney go over with you what the state would have to prove your guilt beyond a reasonable doubt?
Yes.
And he went over the maximum possible penalties you face?
Yes.
No medications, no illegal substances or alcohol, and you aren't receiving mental illnesses, or you don't have mental illnesses or disorders?
No, ma'am.
Excellent. Because you're charged with crimes, you're entitled to constitutional rights, and those rights are listed on both of these documents. You understand those rights?
Yes.
They were thoroughly explained to you?
Yes.
Do you need me to go over these rights with you in any more detail?
If you would like to, but no.
But you understand them?
Yes.
So I don't need to?
No.
Okay. Do you understand that once you plead guilty, you're waiving and giving up those rights?
Yes.
you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
Do you understand that with regards to the plea or attempt to, the state would have to prove on or around November